What I want to tell you about derives from my experience as lead counsel in what is certainly one of, if not the longest running international criminal tribunal that there has yet been. It's the RUF trial in Freetown in Sierra Leone. And one of the things, or perhaps the main message or theme of this lecture, is that the use of joint criminal enterprise in that trial rather resembled a political tool. It was a remarkable case because after 3 years of prosecution witnesses, more than 100 of them, the prosecution case was really in tatters, certainly against my client. And this really is the story, I suppose, of what happens when a case gets too big. It's often said that it's the winner of the war who has the opportunity to write the history. By the same token, it's the prosecutor who has the right to write the history should a war crimes trial follow. And that really is exactly what they tried to do, and succeeded, unfortunately, through means, unfortunately, of twisting the evidence and perhaps misusing the law. Let me introduce you to this man. He doesn't look very pleased with himself, does he? That's because he's about to be arrested for war crimes. His name is Mr Gbao. Now, Mr Gbao was the overall security commander of the RUF. What I'll tell you a little bit more about what the RUF did, who they were, later on in this lecture. But Mr Gbao was charged with two other RUF indictees with a rash of war crimes and crimes against humanity that range from extermination, collective punishments, murder, rape, pillage, sexual slavery, forced marriage. This was the first trial that ever indicted forced marriage. It was the first trial that ever indicted the forced conscription of child soldiers as well. A mass of crimes. It was 18 months ago that I stood up to mitigate in his case. And we in the Gbao team were feeling quite proud of ourselves because although he'd been convicted of most of those crimes that I've just listed, the harsh reality was that all they actually found him individually responsible for, the only direct participation he played at all, was in the relation, and you'll find this hard to believe, but in relation to one offence of planning forced labour and one offence of aiding and abetting the assault of a UN peacekeeper. He was not found, as I found myself saying during mitigation, to have fired a single shot during the war, 4-year temporal period on the indictment, nor had he been found to have ordered a single shot to have been fired. And yet he got 25 years. No wonder he doesn't look very happy. What joint criminal enterprise does, if placed in the wrong hands, and if misused in the way it was misused in this trial, is it essentially reverses the burden of proof, and it allows guilt by association. And yet, as I've said, it is a vital tool for the prosecution. It's a vital tool because when we come to the 3 modes of liability, we will see that those higher ranking commanders are often quite remote. If you look at individual liability, this involves planning the execution of offences, instigating them, ordering them, committing them, or aiding and abetting them. It's basically the individual's part. It's very difficult sometimes to prove that a high-ranking rebel or a high-ranking indictee has been involved on the ground. if that doesn't get off the ground, the prosecution will turn to command responsibility. This is more designed to meet those defendants who did play more high-ranking roles. In order to convict someone on the basis of this, you have to establish the existence of a superior or subordinate relationship. You do that on the facts. What linked the charged man, the rebel boss, to the guys on the ground committing atrocities? Did they report to him? Did he pass orders to them? What were the communications like? The Sierra Leone is a very, very backward country. There are no communications in Sierra Leone. The roads don't work. There's no telephone system. There's no television. In the entire trial, I think we learned of the existence of no more than about 3 radios within the entire RUF movement. And it's also important that to establish command responsibility, the indictee or the accused has to have had the power to prevent or punish individual perpetrators committing crimes. In Mr Gbao's case, it was found by the trial chamber that command responsibility did not lie at all in his case. He was effectively acquitted of that across the board. In terms of individual responsibility, all there was, as I've said, was that incident of planning forced labour. The assault on the UN peacekeeper was a different part of the trial that needn't concern us today. And so, at the end of the prosecution case, the prosecution realised they were in a bit of trouble with Mr Gbao. And in a moment, I'll describe to you how they stitched it up, rather, by altering the way they pleaded the case. Not before their case, not during it. They actually waited until after the prosecution case had closed in August 2007. They apparently forgot the old rule that the defendant ought to know the basis of the case against him before the trial starts, but the trial chamber adapted. I'll come on to that in a moment. First of all, let's look at joint criminal enterprise. This is a little bit complicated, but hopefully I'll explain it in fairly basic terms to make it understandable. There are 3 categories. We'll turn on to those in a moment. They're divided by separate mens reas. As far as actus reus is concerned, and this is common to all 3 categories, you need a plurality of persons acting in concert. In other words, a group of individuals who are acting together. Nothing difficult about that. The potentially difficult part is this, though. There has to be the existence of a common plan, design, or purpose that amounts to or involves the commission of a crime. What this means is that the group or the plurality of persons acting together have to jointly intend that certain crimes are to be committed in furtherance of that common plan. And the third ingredient here is that the accused made a significant contribution to that common plan, design, or purpose. What does that mean? Well, a significant contribution can mean your individual participation, or it could mean you're encouraging or assisting others to commit crime within that common purpose. It all comes down to the facts, and it all comes down to how the trial chamber want to perceive those facts. This is where it gets a bit more complicated. There are 3 forms. Now, I can tell you're already seeing this is way different to the joint enterprise that we're familiar with here. Basic form JCE, form 1, is straightforward. You fulfilled the 3 categories of actus reus, but you now have to fulfill this. You have to intend to perpetrate a certain crime, that being the shared intent on the part of all the co-perpetrators, the plurality of persons I just mentioned. That's quite simple. So you could have a group of commanders who want to go and burn a town in eastern Sierra Leone, in the diamond areas. I'll show you a map a bit later on. They all know that in order to commit that, or to take that town, they're going to burn houses, there's going to be looting, pillaging. They might all agree also to commit various sexual offences while they were there. They may want to kill people in order to take control That's the intent. That's JCE 1. You have a plan, you know how you're going to carry it out, you intend to do certain things to carry it out. JCE 2 I can skirt over because it played no part in the RUF trial. Basically it's the same as 1, it was tailored really for ICTY cases where systems of oppression were in place, such as concentration camps. It deals with those who intend to further those systems. The really complicated thing is JCE 3, and this is the thing that really poisoned the RUF trial, certainly insofar as the case against Gbao is concerned. This is a bit more complicated. It's the intention to participate in and further the criminal activity of the criminal purpose that we've just mentioned. So that's the same. It's the same group of people sharing an intention to commit crimes in order to further the common purpose. But this goes one step further, because JCE 3 covers the situation where further crimes are committed which were outside that common purpose or plan that was hatched together by that plurality of people. But the rule is that a defendant, an accused, can be held liable for crimes committed outside that original intention, provided those crimes were the foreseeable result of the crimes originally intended. I hope that makes sense. They have to be foreseeable, and the accused has to carry on regardless. He has to willingly take the risk that those crimes might be perpetrated. Now, you can see this is already quite complicated, or potentially it certainly is. And you can see also that if the prosecution are going to bring their case, and they're going to prove it, they're going to have to plead it properly. Not only the defendants need to know how they're being accused under JCE, but of course the court needs to know as well. In the RUF trial, everything got horribly mixed up. And what I'm saying, it was a mixture of probably ill education amongst the trial chamber themselves, not understanding the law, but also perhaps a little more sinister, politics played a role in it as well. I've mentioned that joint criminal enterprise is different to the individual liabilities and command responsibility. And I've also suggested that the prosecution rely on it as a sort of a backstop. Indeed they do. You see, in the RUF trial, and this may be in common with other trials as well, as I've said, the prosecution have the right to tell the story. And in the RUF trial, this determination to tell the story, this wide-angled theory, became something of an obsession. The Sierra Leonean Civil War involved atrocities committed on both sides. It wasn't just the RUF, it was the pro-government forces, the CDF as well. It's amazing how little they featured in the trial. There were 3 CDF defendants. Their sentences, despite having been convicted on individual responsibility basis for far more heinous crimes than Gbao ever was, got sentences of something like, was it 8 and 12 years? See, the thing about JCE is it enables the prosecution to tell the story through their own prism, if you like. What it does is it justifies the prosecution to put forward this grand plan, to suggest that, well, they all intended these crimes, and even if they didn't intend them, they foresaw all the others as well. It suits them to say that, because